With the entire world's attention fixed on King Charles III as he prepares for what promises to be one of the most consequential diplomatic engagements of his reign. A high-profile state visit to Washington on April 27, 2026, Prince Harry, the Duke of Sussex, finds himself confronting something far less ceremonial and far more unforgiving: the full, uncompromising weight of American federal law. While the monarchy polishes its image on the world stage, Harry stands at the edge of a legal cliff that has been quietly constructed around him over months of careful, deliberate political maneuvering. And what has emerged in the days surrounding this visit is perhaps the most revealing glimpse yet into just how completely the royal institution has withdrawn its protection from its most controversial member. A quiet but unmistakable understanding has taken shape between the governments of London and Washington, one that speaks not in press releases or public declarations, but in bureaucratic delays and strategic silences. Leaked information has confirmed that the U.S. State Department made a deliberate choice to allow the critical March deadline for the release of Harry's immigration records to pass without action, pushing the disclosure date forward to June 12, 2026. To the untrained eye, this might appear to be nothing more than a government office falling behind on paperwork. But to anyone who understands the intersection of royal politics and American federal procedure, this delay is anything but accidental. It is a premeditated act of political choreography, precise, purposeful, and devastating in its implications for the Duke of Sussex. This is not a bureaucratic hiccup or an administrative oversight buried in the noise of Washington's daily operations. This is a clinically executed political stay of execution, timed to the minute. By ensuring that the explosive details of Harry's visa application, details that circle directly around his openly admitted history of illegal drug use, as documented in his best-selling memoir, Spare, remains sealed and out of public reach until King Charles III aircraft has safely cleared American airspace. The royal establishment has demonstrated a level of strategic sophistication that its critics have long underestimated. The monarchy has not simply kept its distance from Harry's growing legal troubles. It has actively positioned itself to benefit from them while ensuring that the fallout does not contaminate the king's diplomatic legacy. Harry is no longer under the shelter of the crown. He is a private individual standing alone in the crosshairs of federal law, and the countdown to June 12th has begun in earnest. For close to 3 years, Prince Harry navigated his new American life under the quiet but powerful assumption that his royal bloodline granted him a form of invisible exemption, an unspoken immunity from the hardships and bureaucratic struggles that define the immigrant experience for millions of ordinary people. His relocation to California was accompanied by the full fanfare of global celebrity, seemingly placing him in an entirely different category from the men and women who queue for hours at consulates, who fill out form after form, who live in daily fear of a knock on the door from immigration authorities. Harry arrived as a global icon, and for a time, it appeared that the usual rules simply did not apply to him. But the spring of 2026 has delivered a sharp, cold, and deeply uncomfortable correction to that narrative. The man once nicknamed the Spare has finally, irrevocably, run out of room to maneuver. The walls of the legal maze have closed in, and the exits that once seemed available have been sealed, not by accident, but by design. The controversy surrounding his American visa status is not, at its core, a conversation about recreational habits or youthful indiscretions. It is a conversation about whether a man who presented himself to the United States federal government on an immigration application told the truth. And the answer to that question carries consequences that no amount of celebrity, no quantity of Netflix deals, and no volume of public sympathy can neutralize. Under the provisions of the U.S. Immigration and Nationality Act, any individual who acknowledges a history of drug use, regardless of where or when that use occurred, can be rendered inadmissible to the United States. The law is blunt, broad, and largely indifferent to personal circumstances or public profile. In the pages of Spare, Harry chose to be remarkably candid about his personal experiences, openly detailing his use of cocaine, cannabis, and psychedelic mushrooms across different periods of his life. At the time of publication, that candor was widely praised as a mark of honesty and vulnerability. It helped sell millions of copies of a book that shook the foundations of the royal family. But what sells books in the court of public opinion can constitute a federal violation in the eyes of American immigration law. That candor, that openness, that willingness to put his personal history into print for the world to read, it has now become the very instrument of his legal undoing. The central question being examined by federal authorities is devastatingly simple. When Harry completed his DS-160 visa application and reached the section asking about prior drug use, what did he write? If he answered no, if he denied a history that he subsequently published in a globally distributed memoir and profited from extensively, then he committed what immigration law defines as material misrepresentation. In plain language, that is visa fraud. And visa fraud is not a civil matter to be resolved with a fine or a public apology. It is a federal offense that carries, as its standard penalty, deportation from the United States and a lifetime prohibition on reentry. No exceptions. No royal prerogative. No diplomatic back channel capable of making it disappear quietly. The Heritage Foundation, one of Washington's most influential conservative think tanks, an organization with deep institutional ties to the Trump administration and a long history of shaping federal policy, has positioned itself as the primary engine driving Harry's legal exposure into the public arena and forcing the hand of government agencies that might otherwise have preferred to look the other way. Their legal argument is precise, structured, and extraordinarily difficult to counter. It presents the authorities with two equally uncomfortable options, and it does so with the kind of surgical clarity that leaves very little room for political maneuvering. The Foundation's position is straightforward. If Harry was reviewed, evaluated, and ultimately approved for a United States visa despite his widely documented admissions of illegal drug use, then his case represents one of the most egregious and transparent examples of celebrity favoritism in the history of American immigration enforcement. The rules that disqualify thousands of ordinary applicants every year were apparently set aside for a British prince because of who he was and the international attention his case would attract. That, the Foundation argues, is a fundamental corruption of the immigration system and a direct insult to every legal immigrant who played by the rules. Conversely, if Harry concealed his drug history on his application, a history he later chose to publish in a book marketed as his authentic truth, then he committed a federal crime and must face the identical consequences that any other foreign national would face under the same circumstances, regardless of his title, his connections, or his public profile. The Department of State's decision to withhold more than 2,500 pages of Harry's immigration records from public access until June 12 has been described by legal analysts as a masterpiece of diplomatic housekeeping, a move so precisely timed and so carefully constructed that it could only have emerged from the highest levels of coordinated political strategy. By shifting the release date beyond the window of the King's Washington visit, the relevant authorities have guaranteed that the inevitable media storm surrounding Harry's potential legal jeopardy does not bleed into the headlines being written about King Charles's diplomatic mission. The state visit gets its moment of undivided international attention. The Harry problem gets quietly placed in a drawer until the important business has been concluded. This was not a decision made to protect Harry from the scrutiny he may well deserve. It was a decision made to protect the institution of the monarchy from the embarrassment of having its family dysfunction broadcast across the front pages of every newspaper in the Western world at the precise moment it needed to project strength, unity, and relevance on the world stage. The transition from Royal Highness to American tax resident has proven to be a far more brutal awakening than the Duke of Sussex could possibly have anticipated when he and Meghan made their celebrated exit from royal life and touched down in California, with the world watching. For as long as Harry remained a working member of the royal family, traveling on official business, representing the crown at state functions, conducting formal engagements on behalf of the British government, he operated under the protection of the A1 visa, a classification that carries with it a level of legal immunity so comprehensive that it places its holder almost entirely beyond the reach of local law enforcement, civil litigation, and immigration oversight. An A1 visa holder is not simply a visitor to a foreign country. They are, in legal terms, an extension of the sovereign state they represent. They cannot be dragged into civil court by a disgruntled business partner. They cannot be stopped and questioned by local police in a way that infringes on their status. They cannot be subjected to the standard processes of immigration scrutiny that govern the lives of ordinary foreign nationals. Their presence on American soil is guaranteed and protected by the formal relationship between two governments. It is the closest thing to legal untouchability that exists within the framework of international law. And for years, Harry benefited from precisely that protection, not because he earned it, but because of the family he was born into. That protection has now been withdrawn with a finality that leaves no room for ambiguity. When Harry made the decision to step back from his royal duties, Buckingham Palace made a corresponding decision of its own, to formally remove him from any capacity that could be described as official representation of the British state. The consequence of that administrative decree, delivered not with fanfare but with the quiet efficiency of institutional paperwork, was to strip Harry of every layer of diplomatic protection he had previously enjoyed. Without the A1 visa and the formal backing of the British government, Harry transitioned to what is understood to be an O1 visa, a classification designed for individuals who can demonstrate extraordinary ability or achievement in their field. It is a legitimate category. It is also, when compared to the sovereign immunity of an A1 classification, extraordinarily fragile. By issuing the formal confirmation that Harry holds no official role within the structures of the British state, the palace effectively communicated to the U.S. State Department, to the Department of Homeland Security, and to every federal agency with jurisdiction over his case that Harry is a private individual, subject to the full and unmediated application of American law in all its forms. This is the single most consequential act in the entire architecture of Harry's legal crisis. Without the royal shield, the admissions in his memoir are no longer the colorful personal reflections of a prince sharing his journey. They are potential violations of federal immigration law that the Department of Homeland Security is no longer able to overlook under the cover of diplomatic discretion. The Heritage Foundation's lawsuit gained its devastating traction not because of what Harry wrote, but because the palace removed the one layer of protection that might have kept those words from becoming a federal matter. As an American tax resident, Harry now faces a financial reality that is as uncomfortable as it is inescapable. Every dollar generated through his partnership with Netflix, every cent earned from the global sales of Spare, every fee collected from his paid speaking engagements and public appearances, all of it is now fully exposed to the comprehensive and deeply aggressive taxation framework of the Internal Revenue Service. Unlike the considerable private wealth of the royal family in the United Kingdom, which is carefully managed through ancient trusts, sovereign exemptions, and centuries-old legal arrangements that place it largely beyond the reach of standard tax authorities, Harry's California-based income enjoys no such protection. He is learning, at considerable personal cost, that the freedom he sought from the palace comes with a financial price tag that runs into the tens of millions of dollars every single year. And beyond the tax burden, the absence of coordinated state-level security has become its own form of ongoing financial and psychological punishment. When Harry was a working royal traveling on official business, his physical protection was a matter of international treaty, a seamless, legally guaranteed arrangement between the Metropolitan Police Service and the United States Secret Service that ensured his safety at no personal expense and with the full authority of two sovereign governments behind it. Today, Harry is a private individual funding his own security operation at an estimated cost of $6 million annually, protected by a team of private contractors who, however capable they may be, lack the legal authority, the intelligence access, and the governmental backing that state-sponsored protection provides. Every time he steps outside the gates of his Montecito estate, he does so as a man paying for something that was once simply his birthright, and the palace's refusal to extend any formal recognition of his activities as constituting public service is precisely what makes that expense unavoidable and permanent. As the date of King Charles's Washington visit approached and the political atmosphere in the American capital grew thick with anticipation, Donald Trump moved with characteristic speed and instinct to seize upon the Harry visa controversy as a vehicle for one of his most reliable political messages. By publicly framing Harry's continued presence on American soil as a textbook example of the two-tiered justice system he has long claimed to be fighting against, Trump did something that no legal challenge or formal complaint could accomplish on its own. He transformed a private immigration matter into a national political issue with genuine electoral resonance. Trump's argument is blunt, accessible, and designed to land hard with his core constituency. A man who openly admitted in a published book, a book he sold to millions of readers and from which he profited handsomely, that he used illegal drugs should not be lounging comfortably in the California sunshine while thousands of other immigrants face deportation for infractions far less serious and far less publicly documented. The law either applies to everyone or it applies to no one. And if it is not being applied to Prince Harry, then the only reasonable explanation is that his celebrity and his connections have purchased him a form of immunity that ordinary people could never hope to access. That argument, repeated across Trump's media platforms and echoed by his allies in Congress and conservative media, created a political pressure so intense that it forced the current administration into a corner from which there was no comfortable escape. To do nothing would be to confirm the accusation of elite favoritism. To act swiftly would be to create an international incident during a period of sensitive diplomatic engagement with Britain. The strategic delay to June 12th was the only path that served everyone's interests, except Harry's. Buckingham Palace has observed all of this with a silence that is itself a statement of position. By declining to issue any expression of concern for Harry's situation, by refusing to call for his privacy to be respected or for the legal process to be conducted with appropriate discretion. The king's advisors have communicated their stance without using a single public word. They are content, more than content, to allow the American political machine to proceed with its work. The June deadline serves a purpose that the palace itself could never have engineered directly. It keeps Harry quiet, keeps him sidelined, and ensures that he poses no threat to the carefully managed narrative of the king's diplomatic triumph during the single most important international engagement of Charles's reign. Beyond the legal and financial dimensions of Harry's crisis lies a consequence that may prove even more damaging to his long-term prospects: the systematic commercial collapse of the Sussex brand. In the elite ecosystems of Hollywood, Silicon Valley, and global philanthropy, the currency that opens doors and commands partnership is not simply wealth or fame. It is access. Access to power, access to institutions, access to the kind of influence that can move the needle on policy, public opinion, and investment decisions. For a time, Harry's royal identity provided exactly that kind of access. His name opened doors that money alone could not. His presence at an event conferred a legitimacy that no PR firm could manufacture. His connections, real or implied, to the highest levels of British state power made him an attractive partner for organizations seeking credibility on the global stage. That era is over. And it has not ended quietly. The revelation that Harry is operating under the shadow of an active federal investigation, that his residency status in the United States is effectively a political stay of execution, and that the royal family has withdrawn its endorsement of his activities has made him, in the cold language of corporate risk management, toxic to high-value partners. No chief executive of a major corporation wants to anchor a multi-year brand ambassadorship to an individual who may be served with a deportation order or a federal fraud indictment before the end of the fiscal year. No philanthropic organization seeking credibility wants its flagship spokesperson to be the subject of a Heritage Foundation lawsuit and a Trump administration immigration investigation. The commercial silence that has settled around the Sussex brand is not the result of poor content strategy or bad public relations decisions. It is the rational response of a market that has correctly identified that the Sussex brand is no longer backed by the prestige and institutional weight of a 1,000-year-old monarchy. The product has lost its most important ingredient, and the market has noticed. Harry and Meghan's attempts over the years to conduct what critics have called quasi-royal tours, including their recent visit to Australia, complete with charity engagements, public speeches, and the visual glamour of an official state visit, have been rendered entirely toothless by the palace's 2026 administrative decree. Without the formal backing of the British government, and without the A1 visa classification that signals official representative status, these appearances are viewed by the political and diplomatic elite not as the activities of global leaders, but as the vanity exercises of wealthy private individuals seeking relevance they no longer possess by right. In Washington, in New York, in the boardrooms and policy circles where real power is exercised, Harry is now viewed through the same lens applied to any other affluent foreign national attempting to buy his way into conversations he was not invited to join. When King Charles's aircraft finally lifts from American soil and the ceremonial chapter of the Washington visit closes, the quiet period that the palace and the State Department so carefully engineered will come to an end. The Harry problem, which has been managed as an international diplomatic inconvenience for the duration of the king's visit, will revert to what it has always truly been: a domestic federal investigation with a scheduled date of reckoning. The culmination of the Heritage Foundation's legal efforts in June 2026 will serve as the moment of truth, the point at which the files are opened, the records are made public, and the fundamental questions about Harry's entry into the United States are finally answered before the full scrutiny of the American legal system and the international media. The binary nature of what those records will reveal leaves Harry with no comfortable outcome available to him. If they show that he disclosed his history of drug use on his original application and was granted entry through a formal waiver process, Donald Trump and his allies will immediately frame it as the smoking gun they have been promising, proof positive that the immigration system operates on entirely different terms for the famous, the wealthy, and the connected. The political firestorm that follows will be immediate, intense, and deeply damaging to the institutions involved in that decision. If, on the other hand, the records reveal that Harry answered no to the drug use question, that he concealed from federal authorities a personal history he subsequently published, promoted, and profited from in one of the best-selling memoirs of the decade, then the Department of Homeland Security will find itself legally and procedurally compelled to initiate formal visa fraud proceedings. There is no third option. There is no middle path. There is no version of June 12th that ends with Harry's status in America confirmed, secure, and no longer subject to challenge. Without the diplomatic immunity that Buckingham Palace has so deliberately and so pointedly withheld, Harry will face whatever emerges from those files entirely on his own, without a royal shield, without official British government support, without the kind of sovereign backing that once placed him beyond the reach of any legal process in any country he visited. He will stand before the American judicial system as a private individual, subject to its rules in precisely the same way as any other foreign national who finds themselves in legal difficulty on U.S. soil. The period stretching from April to June 2026 will be recorded, in time, as the definitive closing chapter of the Sussex experiment, the end of a story that began with a dramatic resignation from royal duties, a transatlantic move wrapped in the language of freedom and authenticity, and the promise of a reinvented life built on personal terms rather than institutional obligation. The rebellious prince who genuinely believed he could reconstruct the meaning of monarchy from a California estate, who thought he could take the best of what his royal identity offered while discarding the responsibilities that came with it, has been systematically and comprehensively outmaneuvered by an institution that has survived for over 1,000 years precisely because it understands, better than almost any organization on Earth, how to protect itself from those who challenge it. The Crown did not need to engage Harry in a public confrontation. It did not need to issue statements, grant interviews, or fight battles in the court of public opinion. It needed only to withdraw its hand, quietly, completely, and with the cold efficiency of an institution that has outlasted every challenge to its authority, and allow the laws of the land to proceed on their natural course. By the time the visa records are unsealed and the legal storm breaks over Montecito, the royal family will have already moved forward into its next chapter. The so-called Fab Four will have taken center stage. The bonds between the British Crown and American leadership will have been renewed and strengthened. And Harry will be a figure from a previous era, legally categorized not as a prince in exile but as a foreign national under federal investigation, his brand erased not by scandal but by the slow, methodical, utterly relentless logic of administrative process. He will face that reckoning without immunity, without royal standing, without a family positioned or willing to intervene. The half-in, half-out era is dead. The protected prince is gone. The clock has run out. The files are open.